U.S. Army Sergeant Daniel Perry found guilty. We covered this story some time ago. This one's a little bit of a surprise because it comes from Texas. As many of us saw and have commented on for a while now, looked like a pretty clear case of self-defense to us. In fact, there is another affidavit from the lead investigator on the case who says this was a case of manipulation, but found guilty nonetheless. In 2021, Perry was indicted for murder, aggravated assault, deadly conduct charges for shooting Foster during a July 2020 protest in downtown Austin. And there was this scene. Jack Posobiec gave us this photograph. You may remember it. And we made a video about this when it originally happened. Daniel Perry's in this car. He's surrounded by a bunch of other protesters and rioters. And then you see this guy, Foster, right here. Looks like he's got his elbow cocked up. And the gun, right, his rifle is pointing directly at Sergeant Perry. And so that's when the self-defense discharge of the weapon occurred. And that's what caused him to be indicted. So the story says indictment came 1 year after Texans took to the street to protest the police. After the riots, George Floyd, of course, we covered all of that in the Derek Chauvin stuff. Foster attended an Austin protest July 25th. Perry was downtown driving for Uber. They say Perry stopped his car and honked at people, according to police, protesting while they walked through the streets. Second later, he drove his car into the crowd, according to them. Now, Foster, 28-year-old white man, Air Force veteran, had been seen openly carrying an AK-47 rifle at the time, like the one we just saw where he was pointing his arm up. That's legal. There are conflicting accounts as to whether Foster raised the rifle to the driver first, but second later, Perry, who was also legally armed, shot and killed Foster, fled the area, police said. He called the police, reported what happened, claiming he shot in self-defense after Foster aimed his weapon at him. They note Perry is also white. Now, the case sparked debates over the Texas Stand Your Ground law, allows people to use deadly force if they feel they're in danger, but there were some social media posts from Perry sort of speculating that he maybe wanted to involve himself in a situation like this, or that he might find himself in a situation like this. Stand Your Ground law prohibits an individual from arguing self-defense if you provoke the threat. You can't cause the situation and then use self-defense in the middle of the situation to shoot somebody. Judge Clifford Brown said the sentencing could happen as early as next Tuesday, can result in a life sentence, could face at least 5 years in prison, but also could result in life. Guilty of murder. Greg Price also pointed out there's more to the story. The Austin American-Statesman wrote, during the trial, a police officer testified he had seen officers warn Foster at previous protests that he was carrying his rifle in a dangerous manner. Cops said, hey, stop carrying it brazenly like that. It's looking maybe a little threatening. Senior Austin officer Brent Cleveland said during Perry's trial late on Thursday that Foster was visibly and verbally not receptive to police criticism. Cleveland said he never spoke to Foster, but had seen him carrying an AK-47 in a strap slung with a barrel pointed down in previous protests. He told jurors during the trial that if Perry had raised the barrel even a small amount, like we saw in that photo, even that little elbow raise, it could be considered threatening. Told the jurors that. AK-47 bullets can penetrate car doors and police vests. The officer testified that if he had encountered someone with an AK-47 who was carrying the rifle like Foster was, and that person raised the barrel slightly, then he would shoot them. That's what the testimony says from an officer who testified in trial. And you can take a look at that photo right here with the circled, with the Foster individual with his elbow up. And it looks like this is the butt of the rifle. And he's pointing the rifle. He's raising his arm up in a threatening manner. So we have photographs like this. We have testimony from officers in trial about this, that, yeah, if he raised the barrel even slightly, yeah, I'd shoot him. Testifies to the jurors about that. Perry said, I didn't know he was going to aim it at me. Sergeant says, I thought he was going to kill me. I've never been so scared in my life, and I've been to Afghanistan. An officer also told Perry in the video that Perry, who was stationed at Fort Hood at the time, wasn't supposed to be working as an Uber driver in downtown Austin. There are regulations about where Army members can be off base, officers testified at trial. So he wasn't supposed to be in the area, but he was driving Uber. Alexandria Bills, another police crime scene specialist, testified at trial that she examined Perry's car after the shooting and lifted 24 sets of fingerprints off of it. Defense attorneys have said Perry was threatened by a crowd of protesters who surrounded his car and banged on it. Now, that was during the trial. 24 sets of fingerprints all around your car, and you have a maniac with a gun who is raising it up at you while you're sitting there being surrounded by these protesters. So Sergeant Daniel Perry acts in self-defense, and they charge him with crimes anyways. Now, there's questions about the validity of these crimes and about the evidence in this case. State of Texas versus Daniel Perry. The affidavit of David Fugitt. Who is this person? The lead investigating detective in the case. He's working on Sergeant Daniel Perry's charges. He says that prior to the grand jury presentation in this case, I had several conversations with the DA's office regarding the presentation of exculpatory evidence related to Daniel Perry. Now, exculpatory evidence is evidence that shows you're innocent. And because the government has all the cards in the game, they own everything. They have all the police reports, all the cameras, all the physical evidence, all the witnesses come to them. They have all the money. They have everything. So if they know that something is going to exonerate you, our law, thankfully, has said you have to give it to the defense. So this person writing this, David Fugitt, is the lead investigative detective. He wants to bring some attention about some exonerating evidence. He says, it became clear to me when I was called in here during the grand jury presentation that the DA's office did not want to present evidence to the grand jury that would be exculpatory to Daniel Perry and or show that witness statements obtained by the family of Garrett Foster or their attorneys were inconsistent with prior interviews that such witnesses, quote, gave the police and different videos of the incident. So they're all changing their stories and manipulating evidence, inconsistent evidence. But the DA's office doesn't want to present that to the grand juries because they want charges. They don't want justice. The actual officer investigating this, not just an officer, a detective, not just a detective, the lead detective, says, I also wanted to present previous statements from the complainant in count 2, where she never once suggested that Daniel Perry intentionally and knowingly threatened her with imminent bodily harm by driving the vehicle in her direction. So sounds like one of the counts was aggravated assault or attempted murder or assault with a deadly weapon, the deadly weapon being the vehicle. The DA's office also made me remove an animation from Perry's driving the night of the incident that coordinated with his cell phone records that would have refuted the deadly conduct charge ultimately returned by the grand jury. Evidence couldn't even be presented at this very early stage in the case. If this evidence was presented, maybe this case is never even brought. But the DA's office buries it and hides it. Not according to the defense lawyers, not according to Sergeant Daniel Perry or his defense team, to the cop investigating it, the lead investigating detective. He says that more than on one occasion, I was directed by the attorney's office, the DA, to remove exculpatory information that I had intended to present to the grand jury during my testimony. Remove it. At that point, I specifically asked if there would be ramifications if I did not do it. I was told by Guillermo Gonzalez, the assistant DA, that he would ask the elected district attorney, Jose Garza, what would happen if I refused to comply. I was later sent an email simply reaffirming the exculpatory subjects that I was forbidden from mentioning during my testimony. What happens if I don't do it? They said, well, look, don't do it. How about that? Of my original 158 slide PowerPoint presentation, the presentation was reduced to 56 slides with almost all of the exculpatory evidence ordered removed. I felt like I did not have any other options but to comply with their orders. So these rotten prosecutors are so disgusting, they take out 2/3 of the lead investigating detective's presentation out. Too good for our client. Too good for the defendants. Not good for the government. They may not get charges if all this comes in. He says, in my mind, after this directive from Jose Garza is when the conduct of the DA's office went from highly unethical behavior to criminal. they're breaking the law. They're committing crimes. He says, I firmly believe the DA's office, acting under the authority of Jose Garza, tampered with me as a witness. Often witness tampering is subtle. In this case, there were foreseeable consequences if I did not comply and tailor my grand jury presentation as directed, and failure to do so would adversely affect my working relationship with their office for the future. I was afforded no choice but to comply with their directives that were issued by Jose Garza through his statements. Now, I'm familiar with the crime of witness tampering as set out by the Texas Penal Code. I'm a cop after all, and I believe myself to be a victim of the tampering. I declare under penalty of perjury the following is true. Signed, David Fugitt, 2nd day of August, 2021. An amazing statement from David Fugitt, a very honest lead investigative detective. Taking it back against his own DA's office requires an immense amount of fortitude. So shout out to David Fugitt for doing that. But as we see here, even that is not enough. Sergeant Daniel Perry was not given a fair trial in this case because the trial should have never happened because the grand jury was tainted, not according to the defense, according to the government, according to the lead investigative detective on the case.